Good afternoon, everyone. My name's Andrew Dempster. I'm the Director of the Australian Centre for Space Engineering Research here at UNSW. This is the third of our webinars that we've been running this year in lieu of our live events that we normally run. The first two events were on CubeSat's communications and on how to make CubeSat development in Australia more useful. And that's the sort of thing we normally discuss at our CubeSat workshop. The workshop that we're running today fits more with our off-Earth mining forum, which we've been running every 2 years. So it's important that I thank our sponsor. The Space Industry Association of Australia has sponsored these webinars, and we appreciate their contribution. It's very helpful. They've been very supportive of our events over the years, and so we just like to thank them. And I'll just hand straight over to the chair of today's webinar, Cassandra Steer from ANU.
Thank you, Andrew. The first thing I want to do is acknowledge country. So I am based here in Canberra, and I want to acknowledge the Ngunnawal people, but also wherever you are joining us from virtually. I acknowledge the First Nations of Australia and their culture and their connection to land, sea and sky. And I pay my respects to elders past, present and emerging. And I also want to thank Andrew and the team from ACSCR for hosting this really timely and extremely important event, and particularly to Cheryl and Stuart, who are part of the support team. Cheryl, I might actually pass it to you just quickly if there's anything that you want to explain about the use of the chat function and the Slido.
Okay, hi everyone. I'm just going to post a link to the Slido page for this event for any questions that you want to ask of the panel. If you can please post them on the Slido page, and then you can also upvote other questions that you think are worthy of being answered. We also have a poll there. If everyone could take a minute to just answer that. It's very, very brief, but it's just some feedback for the panelists that we might get to discuss right at the end. Yeah, I think that's it for me. If anyone has, if we have issues with the internet with any of the panelists, you may see their video drop out, but we'll try and keep audio on. That's about it.
Great, thank you. So the poll is really to give us an idea of what your background is, because that will help us drive this discussion in a way that's useful for all of you. So I am based here at the Australian National University College of Law. I'm here as a space lawyer, and I'm also a missions specialist with the ANU Institute for Space. A couple of our panelists also have some legal expertise, but we have tried to bring a multidisciplinary perspective on what the Artemis Accords mean for Australia and Australia's position, particularly for industry. And I want to give just a little bit of a background because I'm aware not everyone will have an understanding of the legal or governance context of all of this. So our international space law regime really is inherited from the Cold War era. So the core space treaties that we have were developed very, very quickly and under the geopolitical conditions of the time. So the space race was on, the Soviet and the US interests were really what drove a lot of the negotiations. But what we came up with was 4 very important core space treaties, in particular the 1967 Outer Space Treaty. And we want to think about those treaties as framework or constitutional treaties. So they don't regulate specific behaviors or specific events. What they do is they provide us with excuse me, really important general principles which still are very much the operating basis for space law and space activities today. And one key article of the Outer Space Treaty is Article 2, which states that space is not subject to national appropriation by claim of sovereignty, nor by any other means. Or by occupation, nor by any other means. So this is what makes private activities in space, particularly when we're talking about natural resources and extraction and use and sale, a little bit tricky and contentious. So then in 1979, we have the 5th Space Treaty, which has a limited number of countries that have signed on to it. Australia is one of the 18 countries that have signed and ratified it. And the Moon Agreement was negotiated with a very specific set of interests in mind, in particular, the desire to mine the moon and other natural bodies, asteroids and so on, but the focus very much on the moon. And it allows for the mining and extraction of resources for scientific purposes explicitly. It provides for that being lawful under international law. And then the key article under that treaty is Article 11. And under that article, it states the moon and its natural resources are the common heritage of mankind, which is a term that was taken from the Antarctic Treaty. One of our panelists is going to speak a little bit more about that for us today and compare those regimes. But it's a term that for the US turns out is a little bit contentious as well. That article also states that neither the surface nor the subsurface of the moon, nor any part thereof, or natural resources in place shall become the property of anyone. So for scientific purposes, it's possible, but it also says that states who have signed onto this treaty are obliged to set up an international regime to govern the exploitation of natural resources. So to allow for that to happen in a commercial context, but governed by international law, and to set up a regime and a body to do so. And the obligation is on states to do that at such time as that exploitation is about to become feasible. So when the technology demonstrates that it's now feasible, that point in time is when we should be setting up this regime. But as I said, Australia is one of the few countries that has signed on to this treaty. In fact, it's the only, well, soon to be spacefaring nation once we have our launch capacity in East Arnhem Land as of early next year. None of the other countries, which are states parties, are actually spacefaring in the sense that they have their own launch capacity on their own territory. We do have 4 other signatories, including France and India, but they have never ratified it. So it's never become an obligation under their national law to put this treaty into place. Other countries that have signed it include Austria, Belgium, and the Netherlands, who are all members of the European Space Agency, but they don't have their own launch capacity. And you know, the question really is, are they countries who have or are close to having the technology to be able to mine for resources in space? And then we have countries like Armenia, Chile, Kuwait, Turkey, Uruguay, Venezuela. So there was very much a political impetus in putting forth this treaty and signing it for countries that wanted to make sure that there would be fair distribution of the benefits of these kinds of activities, even if they weren't themselves able to provide the technology or take part in those activities. And so there's a bit of a question as to what was the political impetus for Australia to sign it at that point in time. And it might have had to do with the fact that around the same time, the UN Convention on the Law of the Seas was being negotiated. Again, I'm going to ask our panelist, Don Rothwell, to tell us more about that. And the biggest concerns really, as I said, were about distributive fairness and to prevent de facto land grabs or moon grabs. Even though appropriation and sovereignty is not possible in space, perhaps there may be, while there's a race for resources and a race for this technology, a de facto land grab. So following 1979, not much happened in the way of international space law at all for quite some time. There's been no appetite on the part of states since then to negotiate new treaties. In fact, the US and several of its allies have been very proactive in pushing back against the idea of new treaties. There have been proposals put in place, for instance, for a treaty on the prevention of weaponization of outer space, and the US has been very much against that. And there has been a statement by the US, by certain other parties, that perhaps there's a preference for non-binding instruments. So these could be codes of conduct or guidelines. Most recently, last year, the UN adopted the guidelines for long-term sustainability, 21 very important guidelines adopted by consensus, which have to do with responsible behavior in space, so mitigation and minimization of space debris, for instance. But we don't have anything yet in place that really talks about or regulates or gives clarity on what happens when extraction of resources is going to take place, and particularly what happens if those are non-governmental entities. So of course we've had various technological developments. The Lunar Gateway project has been underway for some time, and that obviously has steps towards perhaps habitation on the moon and certainly being able to explore the moon for resources. China has landed rovers on the moon. India has attempted, though failed. An Israeli company attempted, though failed. But we can see that the international and commercial competition perhaps are either in parallel or supporting each other to have the technology and to perhaps have a right of first claim if one of these countries or companies is able to demonstrate the technology on the moon, which is why we had in 2015, the US adopted an act under the Obama administration, the Commercial Space Launch Competitiveness Act, one of the clauses of that act really brought a lot of pushback internationally. So in that act, they stated that any US citizen, which includes US companies, shall be entitled to possess, own, transport, use, and sell any asteroid resource or space resource, so obviously the moon as well, obtained in accordance with applicable law, including the international obligations of the United States. So what they said was, it is lawful under international law and under the Outer Space Treaty to undertake these kind of activities, and the US government hereby gives rights to companies or any entity to do so, and also said we'll protect any area that you land on it as a kind of right of first claim. And they said this doesn't amount to claiming sovereignty. We're not going against the Outer Space Treaty, but there was an enormous amount of pushback internationally against that. And it's possible that what we see in the Artemis Accords is an attempt to come back at that interpretation. So obviously, last year, Vice President Mike Pence announced the Artemis program and said they would put boots on the moon by 2024. And then in April 6 this year, we saw Trump's executive order. The order was titled Encouraging International Support for the Recovery and Use of Space Resources. And under that executive order, which is a legally binding document, it states that the US does not view space as a global commons. And this is a really important piece we're going to discuss a little bit more today. It also states that the Secretary of State shall object to any attempt by any other state to treat the Moon Agreement as reflecting or otherwise expressing customary international law. So customary international law would be, even if you're not signed on to these treaties, it would still be binding on you. There are certain rules under international law that are binding in that way. It's a bit of an odd statement to make because nobody really asserts that the Moon Agreement would be customary law, but what the US is doing is making a very explicit statement about being against everything that the Moon Agreement was set up to try and do. And following from that, in May of this year, excuse me, the Artemis Accords were announced, or rather the announcement that what the US intends to do is to enter into a series of bilateral agreements. It's based on the Outer Space Treaties, excuse me. And there's a series of principles that they highlight from those treaties. All we have is principles. We don't know what else is going to be in these agreements. We have principles that everybody can agree on. Space should be for peaceful purposes. We should have transparency. We should have interoperability when it comes to the technology, emergency assistance if astronauts are in distress. But then there are two principles which raise some issues, one of which is surrounding space resources. The Artemis Accords reinforce that space resource extraction and utilization can and will be conducted under the auspices of the Outer Space Treaty, with specific emphasis on Articles 2, 6, and 11. So we're going to hear more about that. And also deconfliction of activities. So they assert that they will, in order to prevent harmful interference, they will put in place safety zones. And we might raise questions also about what this might mean and what the basis might be. So that's the background. I hope it wasn't too much of a lengthy background, but I think it's an important background in order to understand the issues that are raised internationally and then specifically for Australia. The first panelist that I would like to give the floor to is Chaplain Squadron Leader Reverend Dr. Nikki Coleman, an extremely important and influential woman within the Defence Forces. She's the Chief Ethicist for the Defence Forces, and she's a military space ethicist in particular. She's taught military ethics to cadets and midshipmen at the Australian Defence Force Academy. She's taught bioethics around the world, and she's published widely on military ethics, liability, and morality. And so I give the floor to you now, Nikki.
Thank you, Cassandra. So just a really short bit about what I do. So I am the Senior Chaplain Ethicist for the Air Force, and I'm the only ethicist in Defence, so that makes me the de facto ethicist for all of the Australian Defence Force. But my main areas of research are in military medical ethics and also in space ethics. So I've been working in space ethics for the last 6 years through UNSW Canberra. So I'm the team lead for the ethics program there in the Space Department under Russell Boyce. And so part of my brief during that time was very, very wide. So Russell just wanted me to explore more about space ethics. So when I started about 6 years ago, there were some really influential thinkers and philosophers working in this field, but it was more of a theoretical field. And so my goal back then, that I hope I've achieved, is to bring more of an applied ethics focus. And the idea about that is to encourage people, whether they are working in a startup or whether they are working in an academic situation or a big corporation or a space agency, to think about the ethical issues that some of their work actually raises. And the reason that that's important is because it actually is about identifying risks early. Ethicists are often given a bad rap for being, you know, the Debbie Downer of everybody's great plans. But often ethicists and lawyers are actually looking at potential risks and potential future risks, not only to what's happening now, but also to future generations. And so it's about mitigating those risks so that we can do things like balance sustainability in the long run against commercial operations, for example. My particular research has been a bit eclectic. So I have published on medical experimentation on astronauts and space tourists. I've written a little bit about space tourism, but the majority of my work has actually been looking at terrorism in space, and particularly looking at non-state groups and how they could actually disrupt our use of space deliberately, and how we actually go about mitigating that as a risk. So I'll leave it there and I'll hand it over back to Cassandra and look forward to talking to the other speakers.
Thank you, Nikki. So our next panelist is an esteemed colleague of mine here at the ANU College of Law. Donald Rothwell is one of Australia's leading experts in international law, and he has a specific focus on the law of the sea, the law of the polar regions, so the Arctic and Antarctic, the use of force, and the implementation of international law within Australia, all of which is very key to what we're talking about today. He's a very prolific author, over 24 books and 200 book chapters and articles. He's consulted or been a member of groups for the UN and the Australian government. And he was the inaugural ANU Public Policy Fellow in 2012 and is now a Fellow of the Australian Academy of Law. Don, I would love to hear a little bit, as a bit of a background, if you could provide for everyone, why your expertise in the polar regions and law of the sea is of use in comparing to what's going on right now and the questions we're dealing with.
Thanks, Cassandra, and good afternoon, everyone. So look, I'll make three observations to begin with. The first is that the 1959 Antarctic Treaty is often seen as a precursor for some of the developments that took place in terms of the regime for outer space that Cassandra has outlined, and also for the law of the sea. That Antarctic Treaty has been in force for 60 odd years now. It has 54 state parties. Australia is of course one of the original parties, and it also has the 5 permanent members of the UN Security Council as members. And whilst it doesn't directly refer to Antarctica as being part of the common heritage, as a result of modifications made to aspects of the treaty through what's known as the Madrid Protocol, Antarctica has been declared a natural reserve to be kept for peaceful purposes. And currently, of course, there's a moratorium on all mining activities in Antarctica. So that's the first point to make. Second point is, if we look at the law of the sea, that's where we do see directly a reference to the common heritage regime. And so that convention, negotiated during the 1970s and concluded in 1982, and currently has 168 state parties, says that the deep seabed, that is the area of the ocean beyond the limit of the continental shelf that countries can claim, is to be part of the common heritage, which means that no single state can assert a sovereignty claim to the deep seabed, and that any exploitation of the deep seabed is to be undertaken consistent with principles of common heritage as reflected in the provisions of the convention. And that at the moment is working through the International Seabed Authority, an authority established under that Law of the Sea Convention, which is based in Jamaica. We we are currently at the point where we may well see deep seabed mining exploration in the next 10 to 15 years, which would be the first time that we see the actual operationalisation of this common heritage principle. Now, the Law of the Sea Convention does not have the United States as a party, and that's a very important point to note. The United States has been consistently an outlier to that convention, which may well reflect some of the US position in terms of common heritage and other settings. And my final observation this afternoon, Cassandra, in these opening comments, is the way in which legally, from an international law perspective, we need to consider the Artemis Accords. Is this an effort by the United States to seek to unilaterally carve out exceptions to the Outer Space Treaty and to the Moon Treaty that you discussed in your opening remarks? And if that is the case, what sort of consequences does that create for countries like Australia, who are parties to both of those instruments and have ongoing international legal obligations with respect to those instruments? Thank you.
That's great, Don. Thank you very much. That's exactly what we're going to delve into more as we start the discussion. So I should also say briefly from here on in, once we've heard from each of the panelists, we're really going to have this as a roundtable discussion or a round virtual discussion, because I think we can learn a lot from the different perspectives, much more through discussion. So the next person I want to introduce is Annie Handmer. Annie is a PhD student at the University of Sydney in the School of History and Philosophy of Science. And she studies, I think, something that is absolutely pertinent to what's going on right now with the Artemis Accords. So the intersection of policy, law, technology, and science, disciplines that don't necessarily talk to each other, but which very much impact each other, and ethics as well. And her focus is Australia's activities in space and in Antarctica. She sits on the Advisory Council of the Space Industry Association of Australia. She's also a member of the Australian Youth Aerospace Association and the Space Generation Advisory Council. So very much an important voice from a younger generation who is going to be impacted by activities that are probably going to be taking place in the next couple of decades. So we're very glad to have her perspective with us. She's also, and I do want to mention this, the host and creator of the Space Junk podcast, which is well worth a listen. Annie, can you provide us some perspective of your multidisciplinary views on what's happening with the Artemis Accords?
Absolutely. Thank you, Cassandra, and thank you also to ACSER for organising today's event. I'm speaking from the lands of the Gadigal people of the Eora Nation, where I am. And before I begin, I wanted to offer a little disclaimer, which is that being a PhD student, I always see it as a bit of a privilege and a curse of being in academia, that we kind of sit a little bit outside of society. And so there's a bit of a resistance sometimes to getting involved in policy discussions because, you know, it might interfere with that role. So I wanted to make it clear that my opinions are my own and don't represent the views of any organisation with which I'm associated, which I'm sure everyone would assume anyway, but also that I think it's important for people like myself to be involved in conversations like this, because I guess I come from a generation that will hopefully, if the pandemic doesn't get us first, be a significant influence on space in future. So the Artemis Accords. Well, I think it's true that technology is advancing rapidly, and it's true that international governance is slow and clunky and often really inconvenient. And that's true whether we're talking about space or whether we're talking about social media. I think it's always been true and it always will be true. But I think it has become trendy to say that because it's inconvenient, because it's slow, that space law itself is out of date and old-fashioned and we need new law. And it's in this vein that I think the Artemis Accords are often framed. And it should come as no surprise if you've read any of my stuff that I disagree with this a little bit. I think international law is built on the idea of transparency and confidence building and mutual reliance. And I guess from a sociology perspective and an ethics perspective, the more links and codependencies we all have with each other, the less likely we are to feel the need to blow each other up, or so the theory goes. So for over half a century, the brightest minds on space from around the world have met to try to resolve differences and reach consensus on how we treat each other in space. And the international treaties that we have as a result of these discussions, which Cassandra gave such a great introduction to, are an astonishing achievement. And I think we need to not lose sight of that. But at the moment, there is a lack of international appetite to form a multilateral treaty governing space resources, either of the sort contemplated in Article 11 of the Moon Agreement or of any other multilateral sort. And I think the fundamental reason for that is that there's a lack of consensus on the issue of space mining. And there are many reasons for that. We don't really know what we're going to mine. We don't know how we're going to mine it. We don't know whether we really want to mine it. We don't know whether it's going to be cost effective or even if we'll be able to use any resources that we managed to scrape off the surface of the moon. And I think we all need to remember that although we all want to talk about space mining and it's very exciting, we've yet to prove the technology works in space. And while there have been developments, I think we're still quite a long way off being able to do it. But nonetheless, the US wants to push ahead, and hence the Artemis Accords. There are parts of the Artemis Accords that I think are great in that they confirm principles in the Outer Space Treaty. There are also parts that raise eyebrows, and I think that that's because the US solution to not being able to form that consensus is just to skip the consensus bit and get straight to the mining in the most efficient way possible, which I think from a sociological perspective, but also just a human perspective, might create a precedent that could damage the hard-won norms of international cooperation under international space law. And I mean norms as in legal norms, but also behavioral norms. There's a few reasons for that, which I'm happy to go into in the roundtable bit, but I don't want to, say everything all at once. The last thing I'll say is that before we get into it, I'm not silly. I am a millennial, but I'm not anti-space mining. I'm deeply cynical, though, about the way that private corporations and governments have historically regulated mining activities in Australia. And I think that sometimes the best and most courageous act is not necessarily just to go with the flow and say, oh, it's all inevitable, this is how it must be, but that we can stop and we can engage in some self-reflection. It's not only a really good thing to do and a nice thing to do, but it is actually an obligation, I think, under Article 11 of the Moon Agreement to take this moment for self-reflection and figure out what we actually think about this. I will hand back. Thanks, Cassandra.
Excellent, Annie, thank you so much. And so our final panelist, of course, is Director of our hosting institution, Andrew Dempster. It will be familiar to many of you, Professor with the School of Electrical Engineering and Telecommunications and Director of the Australian Centre for Space Engineering Research, hosting our event today. And so his world-class research includes 6 patents I read on new location technologies, space systems, research on GPS and on all new GNSS receiver design and signal processing, interference and optimization, and of course CubeSats. And so you are our technology expert, Andrew, and I would love to hear from you the context within which, in fact, you wanted this webinar to take place and the context that you want to provide for us. You're still muted.
I mute myself.
Great,
right.
Thanks.
Okay, good. Yeah, thanks for the introduction. Yeah, rather than the expert, I would probably consider myself a bit of a useful idiot on this panel. I don't really know much about law or those other things, apart from the fact that, apart from the things I've learned from people like my co-panelists here. Having said that, we have run the Off-Earth Mining Forum here at UNSW for 7 years. We've run it 4 times every couple of years on the odd years. And we've had 16 different PhD students looking at different aspects of off-Earth mining. And we are looking at it from a very holistic point of view, from the legal side, the ethical side. We have probably the best work on environmental impacts of this activity. Also the best business cases for how you might go about extracting water from the moon. I have to disagree with you already, Annie. We do know what we're going to mine. We're going to mine water. We're going to mine it from the moon. And so we've been looking at it from a wide point of view. In terms of this panel, I think I'd probably consider myself like a client and maybe representing quite a lot of companies. At the 2019 Off-Earth Mining Forum, we had 11 startups in this area trying to set up businesses that might move into this space resources area. So that's one thing, but the other thing that's increasingly important is the Australian government, the Australian Space Agency's commitment to the Moon to Mars program, which everyone interprets as being a mechanism for joining Artemis. So we Australians, or that group of people, we really need to know about exactly what's going on with the Artemis Accords and exactly how our signature status on the Moon Agreement plays into all of this. So specifically, there are two sorts of things that I would like to ask of the Space Agency in this area. The first one is just this idea of clarification. So that's sort of a passive thing. We say, oh, you could say we interpret these instruments in a particular way, and the way that they affect Australia is this. That's one thing which would be nice. And that's quite passive. I would also like to see a more active approach where we see the Space Agency and possibly other agencies or other areas in the government making Australia's case, saying, look, this is an area of space that we're interested in. We need to, we want to interpret the Artemis Accords like this. We want to interpret the Moon Agreement like this, because a lot of it is still up for, well, the regime that Cassandra mentioned has not been established. So it's almost like the Moon Agreement is incomplete in that way. So why, for instance, would Australia not propose a regime under the Moon Agreement, perhaps a regime that is consistent with the Artemis Accords, for instance? So I would like to see some action on that, because increasingly it's an area where it looks like Australia does have a niche, a sensible niche that we could be looking at to develop in space, because we've got such a strong mining industry here, and the mining automation is very strong, the mining engineering research is very strong. This lack of clarity is a problem, and also possibly some of this lack of leadership is a bit of a problem. Now, I'm going to jump in also. Cassandra didn't mention, we had advertised this panel discussion as including Donna Lawler. Donna was not able to make it here today, but probably at the last Off-Earth Mining Forum 2019, the most memorable thing for me that happened at that event was an observation or a statement that Donna came up with, and it was to do with the Moon Agreement. She was saying that, well, under all of the other, all the instruments that exist at the moment, off-Earth mining, or mining in space, mining on the Moon, is not covered. You cannot say that we're going to do this in space. There's no international instrument that allows you to do it except for the Moon Agreement, and specifically for scientific purposes. So her argument was, for instance, that signatories of the Moon Agreement are in the best position to pursue this activity in space, because we are covered by international instruments. Now, that's a proposition. Obviously, the Americans who are at the meeting all sort of, you know, had steam coming out of their ears, which is what we like to see. And I think the, I'll probably talk about this a bit more later, but the American approach, not just to these international instruments, but also to space in general, may be also a bit difficult for us to deal with. I think that's enough for me. Hand it back.
That's really great, Andrew. Thank you. And I actually really like the way that you say, if you position yourself as a client, we're going to use that in this discussion. I just want to highlight to everyone, Cheryl has posted a few times in that chat function a link to the Slido. If you have a question, the best place for you to post it is in Slido, because then others can also see it, and you can also upvote each other's questions if you think it's a good question, and we can sort of start to gather them there if there are similar questions. That said, I am keeping a little bit of a track of what's happening in the chat, but the best place to do that is on Slido. Also, thank you for filling in the poll, just so that everyone knows. About 60% of the people here in attending as public, as audience, are from an engineering background, about 24% from a legal background, 24% science in general, 3% ethics, 10% government. So that gives everybody, the panelists, but also everyone here attending, an idea of who's in the Zoom room with us. And so that last comment that you made, indeed, I did intend to mention that Donna Lawler was slated to be a panelist with us. She was unable to attend. Her voice and perspective is very much missed. However, we did have discussions with her prior to her not being able to attend. And in fact, the point that you raised about her comment, Andrew, was the very first question I wanted to pose, in particular to Don and Nikki, although with all of the questions that I'm going to ask, please, if anyone wants to jump in. So I think Donna represents a certain perspective that the Moon Agreement is the only meaningful international instrument that provides what we need to support space mining, and in fact puts Australia in a positive position in that sense. So Don, I'm wondering if you agree with that, and if not, what is your perspective on the position Australia is in? And Nikki, if you could have some follow Don with some words about that too.
So I guess the position that I'd take is that the Moon Agreement provides a framework within which moon mining and other associated mining activities in space could be undertaken. But it really contemplates another negotiation, and that needs to be understood. And the framework within Article 11 of the Moon Treaty is relatively broad in that sense. However, the critical issue is that, as you noted in your opening comments, there are only 18 parties to the Moon Agreement. It doesn't have the status of customary international law. I don't really dispute that. And therefore, if a country like Australia was to undertake an initiative to say, well, let's try to get the ball rolling here in terms of an Article 18 additional instrument in terms of moon mining, who would be involved in that process, and what sort of buy-in would other countries have, given that they're not parties to the Moon Agreement?
I have a follow-up question to you, Don, but Nikki, if you'd like to add any comments.
No, go with the follow-up question and then I can make my comment.
So that is this, the obligation is on the states, parties to the treaty, to set up this international regime. But surely there's nothing preventing, if there is international appetite to have such a regime, there's nothing preventing any and all states who want to have clarity to sign up to such a regime. They don't have to first be members, state parties to the Moon Agreement. And if that's the case, wouldn't that be a preferred way forward if we have concerns about the Artemis Accords?
There's an argument that you could make along those lines, but that would suggest that you're starting from scratch. Now, it may well be that given that the Moon Agreement was concluded in '79 and it's had so little uptake, a position could be taken that the Moon Agreement should really just be abandoned, and countries like Australia should try to develop an alternative approach. So I think that's a critical legal, strategic, geopolitical issue that would need to be borne in mind by any country such as Australia who is trying to move that initiative forward.
Okay, Nikki, I suspect you have a different position on that.
Slightly, but it's similar in a way, and it goes into what Don was talking about buy-in. My concern is that we have the Outer Space Treaty, which has a lot of signatories and a lot of countries who've signed on to it. The Moon Treaty, who has actually, which we have ratified, but there aren't that many countries who have joined on for it. My biggest concern with the Artemis Accords is that it's actually not a multinational approach to this, but it's actually a series of bilateral agreements. My concern is that it means that we are all kind of working on this in an individualistic kind of nation state kind of approach, rather than taking a bigger approach in regards to a wider group of spacefaring nations, but also other states which actually are consumers of space. So not just those countries that have a space agency or who have launch facilities, but all of those, say, for example, developing countries who don't actually have necessarily their own assets in space, but who actually want to talk about potentially what happens on the moon and other celestial bodies in the longer term. And so my concern is mainly that something like this, where we're actually breaking the process of actually us coming to consensus down. Having said that, I am actually really excited because I think it's great to see some leadership in this, and it's great to see that we're actually starting to think think about how we will actually handle this problem. As Annie was saying, you know, we've got to get this right, because this is going to impact not just us, but also future generations. So we need to work out how to actually ensure that we get this right. So I think it's great that we are actually starting on this road, but I have some serious concerns about the process and how we kind of move forward from that.
So there's actually a question here on Slido that's been upvoted. It's the most popular question. And Don, again, I'm going to ask this to you, but anyone, any of the panelists, should Australia therefore consider withdrawing from the Moon Agreement? It's provided for in Article 20 of the treaty. You provide 1 year's notice and then you say, we actually are withdrawing from our obligations under this treaty. Is that something Australia should consider?
I guess the position I'd take is that if Australia was to do that, it would certainly provide a clean slate. It would make it easier for Australia to provide leadership with putting forward an alternative and more developed regime in terms of mining activities. But as we've seen recently in terms of other matters of international affairs, Australia would need to be very cautious about going down this route unless it had support from other major states who are parties to the Moon Agreement.
Annie, do you have an opinion on that?
I mean, of course, always. I think, to be honest, abandoning a treaty or withdrawing from a treaty is a big deal. And I'm sure Don can speak more to this. But for Australia to go and say we're withdrawing from the Moon Agreement has a significant impact beyond just the Moon Agreement. It really sets a bit of a precedent, I would be concerned, for the idea that you can withdraw from space treaties or decide that because they're a bit inconvenient, you know, why would I be part of it? And the other side of that is I think that Australia does have a really good platform under the Moon Agreement at present to take a very active role. And I'm in furious agreement with Andrew on this one, that Australia ought to be going out and making a case for what we want to be happening with the moon and with mining and so on. And I think that under Article 11 of the Moon Agreement, we really have a platform under which to bring, to bring people to the table, to take a leading role in that we would not have if we were not a signatory to the Moon Agreement. But on that, I think it's very important that if we're going to go through with that, we keep it as an option open, that we propose a regime that doesn't necessarily just tie in neatly with the Artemis Accords. It's okay for us to disagree a bit on certain issues, and we may indeed decide that we do that. But the first step has got to be that Australia decides, you know, what we actually think about all of this before we go running around withdrawing from treaties or signing up to new ones. There's got to be a bit of reflection and so on. But, you know, maybe that'll end up being the right one. But I would be really sad to see us withdraw from the Moon Agreement just because it was inconvenient at the time.
Andrew, is it okay then from an industry perspective, do you think, to say, well, we'll come up with a new regime. We wanted to try and tie it in with Artemis Accords, but we don't have to. If we disagree, well, we'll disagree. Is that, you know, is that supporting what industry wants to hear? Do you think that puts in us a dangerous position in terms of being able to be in partnership with the US?
I'll probably come back to that question. There's a couple of things. One thing which I would probably put back on either you or Don would be if Australia withdraws from the Moon Agreement, does that affect how other countries would see us for all of our treaties, like a sort of unilaterally withdrawing? Responding to what Annie just said, would that problem be mitigated if there was a viable alternative on the table? So not withdrawing from the agreement full stop, but saying, well, we're actually going to replace that agreement with this one. Is that a more sensible way to go about it? So I've basically just asked questions and not answered anything. But to come back to your question, the research that we've been doing, right? So we've categorized the research that we've been doing in this area, all of it across the board, as how do we reduce the risk perceived by an investor in a space resources venture? So there's legal risk, there's ethical risk, there's environmental risks, there's investment risks, technical risks, all of these risks, right? So there's tons of research to do, great opportunity for people like me. But I don't think the business or the people who are doing this really care about whether it's this treaty or that treaty. They just want certainty. So that was the point I was making about clarity, right? So if we know exactly where we stand, then either we can do it or we can't do it. Great, decision made, right? That's the sort of thing that that I think the people who sort of I'm representing in this discussion, I think that's what they're interested in.
Don, do you have anything to say about the question that Andrew posed in answer to my question? So what would that do if Australia were to withdraw from this treaty?
Well, the first point I'll make is that Australia has announced today that it's suspending the Australia-Hong Kong extradition treaty. So governments make decisions every day which see treaty arrangements suspended. I think that in the case of the Moon Treaty, look, at the end of the day, this is a treaty which hasn't clearly proven to be that successful. It's only got 18 state parties. A decision could be made that, look, the better thing for Australia is to abandon this treaty and to move forward along the lines that we're discussing. Recall that in the 1980s, Australia spent 6 years negotiating a mining regime for Antarctica. And then 1 year after that convention was concluded, the Hawke government abandoned that treaty and took the very bold step of saying, no, we're not going to mine in Antarctica, but we're going to put forward a proposal for a comprehensive environmental protection regime. Now, that was done in collaboration with France, and that's why I say that if Australia was to take the sort of steps that we're sort of musing here, diplomatically, it needs to be realised that this would be a very, very big undertaking, and it's not something that I think Australia could possibly do on its own.
Yeah, so I'm going to take up the invitation to comment on it as well, Andrew, which is that I agree emphatically with your last comment, Don. And in regards of, so the impact of withdrawing from a treaty, we know what the impact is diplomatically and internationally, because there's a huge response in the past when the US, for instance, was in huge support of creating the International Criminal Court. We need a permanent court to deal with crimes of mass atrocity. And then under George Bush Jr. said, well, actually, we're withdrawing. And that's a massive political statement and has left a bad taste in the mouths of many who work on those issues. So we know what the optics are and what the impact is. It sends a very strong message. On the other hand, and I'm going to ask a question about that in a second, we're not really, as far as I understand, quite clear what the strong message was meant to be at the time that Australia decided to sign on to this treaty. But you also said, Andrew, that what's really important for industry is clarity and certainty. And unfortunately, that's exactly what we lack around these kind of activities in space. The point is, there is no clear and certain law on these issues. What we do have is, because the Outer Space Treaty, Article 3 says all activities in outer space must be in accordance with international law. International law applies in outer space. So there's certain other bodies of international law that therefore apply. So human rights will apply when we're talking about interaction between astronauts, or once we have space tourism, for instance. Environmental law applies. And so obviously certain areas of it are not relevant when we're talking about protecting endangered species, but other areas are if we're talking about planetary impact of our activities. The precautionary principle, for instance, some might argue is a customary law norm which says if you don't know what if there's a risk of serious consequences of your activities and you cannot prove that they won't happen, you should act with precaution. So perhaps we could say that already exists in terms of considering the impact of mining activities. You know, the law of armed conflict applies. So there are bodies of law which give us some clarity around activities in space, but we don't have anything that is granular enough to regulate these kind of activities. And so right now, that's the whole point of what's going on. National legislation can be put in place the way the US has done, but if that's not in accordance with international law, all that does is create even more confusion and lack of certainty. And so my take on it is we either need to have a multilateral international regime, a multilateral process that would lead to a new governance regime. We don't have clarity, we need to create it, we need to come up with something new. Or the alternative is do what the US is doing, which is saying these activities are going to take place anyway. It's inevitable. We're not even going to discuss whether they should. They are going to take place. Given that the US is the technological leader at the moment, it's just simply positioned itself as saying, we're going to decide who gets to be in the club. We're going to decide who gets to have a bilateral individual agreement with us. And if you want to be part of what we're about to undertake, you have to agree to what we're saying goes into these accords. And it may well be that they have the force and the technological advantage to be able to push with that process ahead. But I have massive concerns about that for similar reasons as Nikki. So unfortunately, there is no clarity. So how do we get to that clarity? Nikki, I wonder if I could turn to you again then, so you've said you have concerns about this bilateral process. Can you say a little bit about what that means in terms of, is that going to lead to pressure to follow the US interpretation of international law? Are we going to end up with a regime anyway, even if there's not a consensus on it? And also why that process is important and why perhaps concerns about ethical distribution is important.
So you just highlighted a really important thing, which was this is bilateral agreements. It's not actually multinational agreements. At this stage, we don't know how transparent they'll be. My biggest concern is that we will have a whole series of opaque bilateral agreements, and so we actually won't be able to see what the final effective body of these decisions are. I think whilst it's admirable that America is actually leading the way in this, it concerns me that they actually are holding all the cards, so they actually get to decide on what the position is for all of the world. And so there's a little bit of concern within space ethics circles that, who gave America permission to make these decisions on behalf of all of us around the planet and also future generations. And so there's a concern around that. In regards to, you were talking about how we actually ensure that we make sure that this is distributed, that the risks are distributed and also the benefits are distributed. So I was at the first Space War and Ethics conference in Colorado Springs last year, and there was a fantastic speaker who came from Botswana, and what he was talking about was he's trying very, very hard to get his people involved in thinking about what the future of space should be for them as a country and also for them as a world. But it's really hard because they've basically just given up and said, well, we're not rich enough to be able to have our own assets in space, so why, we should just in a way roll over and agree with what everybody else is saying. And he found that incredibly sad because they're losing their voice in this discussion. I think it's unlikely that America will actually have a bilateral agreement with Botswana in regards to the Artemis Accords. And like you said, it means that it kind of shuts them out of the club. My other concern also is looking at the Artemis Accords, it's almost as if America is only talking to the people who agree with them. So currently there's not been some discussion around them having agreements, for example, with Russia and China. Now, those are huge spacefaring nations who have actually been quite active in saying, we want to do activities on the moon and other celestial bodies as well. And so my concern is that the Artemis Accords need to meet the needs of all of us, so all nation states. But at the moment, they seem to be set up to only be meeting the needs of particular countries. I would have loved to have seen America show the same amount of leadership, but actually push it in a different direction and say, right, we're going to have a new moon agreement, or, we agree wholeheartedly that asteroid and moon mining will happen, and we're going to push forward some multilateral agreements. So I'm very wary because we have come to the position that we have a series of bilateral agreements. The fact that they've gone in that direction kind of concerns me ethically a little bit, and I'm very concerned about the countries that don't have the same amount of negotiating power with America, but also those countries who actually aren't actually going to have these bilateral agreements with America. And by not having their voice in all of this, that is concerning, because what are we losing? What perspectives are we actually losing?
That's excellent. So I just want to note, because we're getting close to 1 hour, but what I want to do is keep tying in questions from Slido into our discussion. So rather than saying we're now moving to Q&A, that's just happening as we discuss. Annie, I want to pass to you because I see that you have a response to what Nikki just said as well. But before I do, the most popular question right now on Slido is how do speakers feel about the bilateral approach? Clearly that's been articulated, but should these discussions not be held in the open? And then another question, which is, I guess, it's kind of related to this, you know, right now it's a unilateral interpretation. It's a unilateral position from the US determining what's going to be in these agreements. Someone has asked the question, even saying that it has to be scientific mining, it seems to remind this person of the Japanese whale hunting precedent, where they said, well, what we're doing is for scientific purposes. So is that even enough? Even if we're talking about, you know, these kind of more general principles and interpretation, isn't it easy to kind of twist that interpretation? So it's kind of two questions there, but Annie, I think you had some words to say.
Thank you. I just wanted to say that I thought what Nikki raised there as the ethics of countries that are non-white, non-Western, not as wealthy as we are lucky to be in Australia, you know, their voices also matter. And I think from that perspective, there are probably two bits of the Moon Agreement and that don't seem to gel with the Artemis Accords. One of those is the safety zones and sovereignty bit, and I'm going to shelve that because I'm sure that everyone's got lots to say on why a safety zone is not like a sovereignty or something like that. It gets a bit Lewis Carroll sometimes, but the other one is about common heritage and benefit sharing. And I think that under the Moon Agreement, there was an explicit acknowledgement of the fact that the resources from space should be, you know, activities done should be for the common benefit of humankind, that it's the common heritage, and that implies in it not only that it's a global kind of way that we need to think about this, but also across multi-generations into the future. Now, as I understand it, the US has a real problem with benefit sharing, and that's one of their fundamental issues with the Moon Agreement. And the reason for that, I think, is probably an ideological one, that benefit sharing sounds a little bit communist. But Nikki's laughing. But I actually think that this is a really big issue. The move that I think the US is taking is to say, well, no one owns the moon. No one owns space objects or space bodies in space. No one owns them, but it's okay to chip bits off them and sell them for profit, regardless of the fact that no one owns them, which is a bit different and a bit of logical gymnastics, as opposed to the Moon Agreement perspective, which you might interpret it. Again, interpretations vary, but that would be more along the lines of, well, we all own it. We all have to have some say in this and some benefit from it. So I think that ties back to the bilateral versus multilateral concern, which is that if we're talking multilaterally, everyone gets to have a bit of a say in it. And I think that's actually really good in terms of constructing a way of operating with each other that is more peaceful and doesn't lead to more inequality and more conflict down the road. So that was what I wanted to say on that one. But I'd be really interested also to talk about the safety zones and hear from some of the other panelists what they think, because that one's a complex one. Whoop, you're still muted.
I've muted myself. So let's go there, because there have been quite a few questions raised by people in the audience as well about safety zones. Let me just... So, and perhaps we can tie it in with this question. So you raised also this common heritage of mankind, global commons. These terms get bantered around, and now the US has said explicitly we don't consider that to be applicable. Someone has asked, is common heritage of mankind a bit like declaring an area terra nullius, empty land belonging to no one specifically, the way that it was used in Australia? And if not, I think the answer is no, but perhaps Don, you could elaborate on that. If it's not that, what is it? And then let's talk about safety zones, because that is tied up in that idea. If it is global commons, what does that mean about safety zones? If it's not global commons or common heritage of mankind, what does that mean about safety zones? Don.
So I don't think it's appropriate to use the terra nullius example here. If only just because it has a terrestrial dimension to it. But the notion of common heritage says that an area, however we might define that, is really not subject to notional appropriation. no one state can make a claim to that particular area, whether it's the deep seabed, whether it's outer space, whether it's the moon. But then the question about the principles that apply in terms of engaging in exploration and exploitation, they need to clearly be developed in terms of allowing for peaceful purposes and the pursuit of legitimate scientific research and indeed legitimate commercial activities. And that's where I come back to my observations about the fact that the work being undertaken by the International Seabed Authority, I think actually provides a really useful precedent to look at in terms of the way in which these types of activities could be undertaken in space. But we also need to observe there that the United States has remained outside of that framework. But in terms of Nikki's observation earlier, that's exactly where countries like Botswana and developing states actually have a very prominent role, because there's a mechanism there within the Law of the Sea Convention for developing states to be very actively engaged in the development of these regimes in the case of the deep seabed.
Let's carry down that line a little bit before we come back to safety zones then, because there have been several questions about this as well. And Annie, you said, you know, perhaps the US ideologically isn't interested in benefit sharing. You know, obviously there's also a commercial aspect to that. If you need to make a business case for, first of all, developing these technologies, the enormous investment that goes into that, testing it before we even get to being able to extract and make potential profit from it, and then you're being asked to distribute those benefits. Andrew, is that from the perspective of industry something that you think is too great a hurdle? Because it is something that is envisioned in the Moon Agreement. Let me just go quickly back and say that the international regime that's envisioned within that, the Moon Agreement lays out 4 key purposes are the orderly and safe development of natural resources of the moon, rational management of those resources. What happens if we have permanent habitation on the moon and those people need access to some of those resources for survival? We can't simply strip them out and be selling them for terrestrial profit. The expansion of opportunities in the use of those resources. So it's a regime to support the commercial industry, and an equitable sharing by all states parties in the benefits derived from those resources. So something that looks a bit like the international seabed regime. Is that kind of thing too much of a hurdle, do you think, Andrew, for industry?
Sorry, so you're asking whether the Moon Agreement does not give industry enough flexibility?
Yeah, or just the very idea of a regime that envisions distributing the benefits.
Well, I mean, again, and I think we sort of discussed this, or the legal people discussed this in some detail at the last Off-Earth Mining Forum. That idea of distributing benefits can be interpreted in a number of ways. You know, like maybe you pay some tax, whatever that means, to someone, to some international body or something. And if you've done that and then it gets distributed elsewhere, then there are benefits to everybody. You know, but you could have a regime that, but what I'm trying to say is that we need clarity on this. The other problem that I sort of came to my mind with some of the earlier discussions is that, am I right? I mean, I'm asking you lawyers, it's my understanding that none of these space treaties have ever been tested. Like there's never been a case where the governing legislation that's being used in the court is one of these international space treaties. Is that right?
They've never been tested in a court of law, right? So there's 2 things you could say about that. One is, so the liability convention has been triggered once when Roscosmos had a nuclear-powered satellite broke up and landed on the Northwestern Territories in Canada, causing environmental damage. And Canada said, in diplomatic notes, we refer you to the liability convention. We want you to pay for the cleanup. And Russia said, we'll pay for some of it. And that was as far as it went. So it was never taken to court, but it's a demonstration that states rely upon the treaty and respect the treaty. And so you could also say the fact that they've never been tested in court is a good thing. That means that there is general consensus about how they operate. Again, they're mostly general principles. They're mostly putting in place things like no appropriation and sovereignty, peaceful purposes. We all agree that military operations can still take place as long as they're not aggressive. You know, taking into account due regard. So these general principles, even questions of liability, we have the Registration Convention, which doesn't have 100% compliance, but in general, there's an enormous amount of respect for what these principles are. So they haven't needed to be tested. Now we've come to a contentious issue of mining and we don't have anything to test. That's the problem.
Yeah, but I mean, what I'm really saying is that idea of distributing the benefits is so open to interpretation, right? That you can come up with 100 different ways of doing that. And no one has come up with any. So, you know, whether what you do meets your treaty obligations or not is you know, because it's never been tested in any way, like, no one's ever even tried to do it, then I think it's very difficult. And part of what I think, when I'm asking for clarity, part of what the Americans have done, less so with the Artemis Accords, but maybe a bit more with the Trump's statement.
His executive order, yeah.
Executive order, right, is they are saying, okay, we are interpreting it like this, we are interpreting it like that. And so because it's a very interpretation-rich environment, then the clarity is being delivered by making explicit statements of how you're going to interpret the instruments.
So this would be something that we would love to see from the space agency or from the government as a whole, is to have some statements about, we interpret this to mean that, this is our stance on the issue.
And we're in a very special position, you know, because we're effectively signing up to Artemis, not necessarily the Artemis Accords, but to Artemis, and we're a signatory of the Moon Agreement. At the moment, no one else is in that box. Now, it's a Venn diagram with one country in it, right, in the intersection. So no one knows, no one has said what our position is. We need to know.
So I think it's a really excellent point. We're at a really exciting point in the fact that the space agency is only 2 years old. Commercial space sector around the world is looking with great eagerness and excitement to Australia to see, what does it mean that we now have a space agency with an explicit mandate to support industry? Given now that the Artemis Accords are going to be there, given now that the Artemis program is very much in action, our Moon to Mars commitment is already there, we're actually in a really exciting moment where Australia could take some leadership on this, some proactive, positive leadership, and say, if we consider ourselves to be a steward of complying to international norms, a steward of sustainability in space, then this is the stance that we're going to take. And that stance can still be incorporating working together with the US, and it also perhaps would put us in a better position once the US is ready to negotiate the content of an Artemis agreement and say, well, we've already made this statement about our stance, so now let's put both of our stances into that agreement. So I think you make it.
What you're saying, I agree completely, because this isn't a problem, this is an opportunity.
Exactly.
This can put Australia on the map in space, and it can really make our mark. If we are looking to do something unique, this is a good thing to do. Let's do this.
Exactly right. And I think that answers a number of questions that have come up on Slido about, does the Moon Agreement put us in a disadvantaged position? You know, what about countries who, how will the principles be applied amongst countries that haven't taken part in these Artemis Accords? Could Australia perhaps then say, right, let's still move towards a multilateral regime that incorporates these principles, so that countries who haven't been selected to be part of the US's inner club can still partake in this whole process. So that, I think that answers a few questions that have been coming up. So let's talk about safety zones, because that's also coming up. That's been upvoted and it's been raised a few times, and it's something that is contentious in those very, very vague principles that NASA has provided us in their PDF of what the Artemis Accords was supposed to cover. So just to state again, they have said that for deconfliction of activities, so if one country or one company has landed in a particular area, to prevent harmful interference, and also perhaps to prevent the safety of operations and of humans, if there are humans involved in these operations, that safety zones could be implemented. There's a lot to say about that. I'll start with Nikki, if I can, and then Don, and then Annie.
So we've alluded to this a little bit earlier. I guess the biggest concern is that safety zones effectively becomes a land grab. And so I'm going to send as many different robotic probes onto the moon to grab an area. We've seen a little bit of space grabbing with Elon Musk setting up, huge amounts of satellites to claim whole orbits. So there's a little bit of a concern there. So my concern is really that a safety zone actually turns into a de facto sovereignty, that people are actually claiming them. Having said that, in theory, I really like the idea of a safety zone. It's about, like Andrew was talking about before, it's about environmental sustainability. It's about making sure that we're not having a huge impact. It actually has a great capacity to be used for the right thing. My concern is that we ensure that it's not actually abused and used against the spirit of the idea, which is safety zones, so that we can actually utilize the moon for everyone. Let's use it responsibly, which is what the safety zones could be. The concern is if it's used in a nefarious way.
So the point I'd make there, Cassandra, is that this notion of safety zones is really not that different from the way in which the Antarctic Treaty allows countries to build and establish scientific research bases in Antarctica. But the Antarctic Treaty neutralises claims to sovereignty. So even though Australia has 4 bases in Antarctica, and China has quite a number of bases, and the United States has a very large base, and including a base at the South Pole, those bases are not a basis or a foundation for a claim to sovereignty, but are there for legitimate scientific research purposes. So I agree with some of the points that Nikki's been making in that regard. And if you think that Article 2 of the Space Treaty holds firm in the sense that these areas are not subject to national appropriation, well then safety zones, no matter what they might be called, could be seen as being quite consistent with the framework of the existing legal arrangements, but really allow for space activities to be ongoing.
Annie, do you have, what's your take on it?
Look, I think as with a lot of things, the words don't really matter that much. What matters is how everyone acts. It remains to be seen what they'll end up being like. And I suppose a couple of points on it would be that if there are to be safety zones and it is to be a positive thing, then they probably need to be regulated. And then that goes to the next point, which is ideally they would be agreed multilaterally. But the trouble with the Artemis Accords is that, we've seen a bit of opposition from Russia. It seems unlikely that China will be invited to agree on these safety zones with the US. And as a result, I think it's entirely possible that the US shows up and says, this is our safety zone here. And another country shows up and says, well, we don't recognize that because it's not under the international treaties. And that is a risk. But we don't know. We really don't know. We just have to wait and see how it plays out. And I think that as much as possible, multilateralism is the way to go with this one where we can. And maybe that's something Australia can think about, whether we can play a role in helping to avoid potential future conflict.
And I think that's a really key piece too, is that historically, wherever there's been a race for resources, that's led to conflict. Because it's competition commercially, because it's competition between states. And historically, it's also been about expanding empires and land grabs. So while that may not be possible under international law, I share Nikki's concern about the de facto effect of it. And also the fact that if safety zones as such are accepted without being regulated, and I think you're right there, and it just needs to be regulated as part of an international regime. If they're not regulated and they're just something that can be declared, well then we're going to see that being declared around orbits, around satellites, meaning that perhaps any satellite that accidentally or deliberately comes too close within a safety zone, does that then raise questions in terms of, are we looking at now a threat of force? What does this mean in a military context? So it's contentious. And Andrew, you keep saying clarity is what we need. And unfortunately, the typical lawyer's answer to any question is, well, it depends. So I think the one piece of agreement across the board here is, in order to create more clarity, Australia really needs to take a stance and perhaps find ways of moving towards both working with the Artemis agreements and supporting some kind of multilateral process. There's a question that has been upvoted which hasn't been asked before, which is, given that the position on space mining, and I think we can say the same if safety zones hasn't been tested, should the General Assembly seek an advisory opinion from the International Court of Justice? So the International Court of Justice is the court that would hear, that hears any contentious issues between states. It would also hear if there were issues about the Outer Space Treaty. Not necessarily the Artemis Accords once they're in place, that maybe that there's also an arbiters process or something else put in place. But the ICJ is the court that hears issues between states. They can at times be asked for an advisory opinion. So an issue hasn't actually come up between states, but they might be willing to give an opinion, as they did on the legality of the use of nuclear weapons, as to the legal answer to that question. Is that something that should happen, Don?
It's a process, as you've outlined, but it's a very fraught political process. And of course, it needs to be noted that any advisory opinion is non-binding. I think the more appropriate role for the General Assembly would be to seek to neutralise this debate, to actually place a moratorium on mining in outer space until such time as there is a multilateral legal framework in place. And here I point to the precedent of the way in which the General Assembly responded to that issue in terms of the deep seabed in the late 1960s.
And if a moratorium is placed from the General Assembly, and this goes to another question that's gained a lot of votes, what do we do about enforcement? A General Assembly resolution, even if it's unanimous, is also not binding, and it wouldn't prevent the US from going ahead given the amount of investment that's in these projects already. What do we do about enforcement? And the question is posed as, isn't it going to be a bit of a Wild West initially? Do we believe that history won't repeat itself? So Don, and then Nikki, and then Annie.
Well, I guess any country that sought to go outside of a UN General Assembly resolution, which had very high levels of acceptance, and that needs to be pointed out, would be seen to be acting unilaterally, would be a rogue state. And given the sort of need for collaboration and cooperation in terms of space activities, that could be quite detrimental, even for a country like the US.
Enforcement will be difficult, I agree, but just because something is difficult doesn't mean we shouldn't actually aspire and try to do it. This is a situation at the moment where having no way of moving forward, having no framework for us to work in as different states, as commercial operations, etc. If we have nothing, then that is actually worse than potentially having something that is not ideal. And a lot of my work with the Biological Weapons Convention showed me that when you get everybody at the UN trying to actually agree on things, it's really hard, but that doesn't mean it's not important, and it doesn't mean that we shouldn't actually try for those discussions. And I think that's a situation such as this. Just because we don't have an enforcement situation at the moment, an enforcement a way of enforcing potentially, for example, countries on the moon actually disagreeing with each other or claiming similar sovereign territory or claiming sovereign territory. Just because we haven't actually set that up doesn't mean that we should just give up, because actually giving up is the worst thing that we could possibly do.
Hey, excellent, it's working. Look, I think that the question of compliance and enforcement, like a lot of human activity, ultimately boils down to power. It's about whose has it, how it's systematically removed from individuals and groups and nations as it suits those who have the power. And I think that international law itself, from a sociological angle, if we're looking at social constructivist theory, for example, and I promise not to go too into it because it really puts people to sleep, especially engineers, but it means that international law only has the power we give it. It's a piece of paper. It's like a wedding. It's like a marriage. It's like you sign a piece of paper, but really what gives that any sort of social viability is that it's a ceremony and it's all very important and everyone knows it's a thing and you continue to enact it over time. And it means that you continue to give it power and relevance. Now, when it comes to the international space law, I think that if we put off the difficult conversations now, and I'm with Don and Nikki on this one, and Andrew actually, we're just kicking the can down the road. And as part of the new space generation and a proud pesky millennial, I think Australia is pretty hipster for having signed the Moon Agreement before it was cool. But I also think that I'm really interested in ensuring that Australia's activities on the moon and the way in which we negotiate and decide them as a nation leave the best possible legacy for intergenerational responsibility and ongoing peaceful international cooperation in space.
Thank you. There are more questions here, but I feel like everyone's made a very clear stance, and that was a beautiful summary. So I'm going to do two things. There's a couple of questions that come up that have come up in a few different ways that I'm going to attempt to answer myself because they're seeking clarity rather than discussion. And then we're going to ask each of the panelists if you have any final comments. So please take the opportunity now to panelists to think about what your final comments might be. So for instance, the question has come up in various forms about this idea of global commons or a common heritage of mankind, and whether that means that space and the moon and asteroids belongs to everybody collectively. So do we need someone to represent collective interests, or to nobody, and therefore they're kind of up for grabs in a free-for-all? That question was posed in various different ways, and I think the answer is that a global commons or a common heritage of humankind, the intention is really to say it's a collective responsibility rather than ownership. So it's not about ownership rights. That terminology is put there next to terminology that says sovereignty is not possible, appropriation is not possible. And so those concepts were agreed to already in the 1950s in the Antarctic Treaty, and in the late 1960s in the height of the Cold War in the Outer Space Treaty, specifically because even in these times of competition, states realized if they wanted continued access for their own interests and benefit, they needed to ensure that no other state was going to be able to claim a sovereignty at any particular time. So there was an agreement to say, no one can own it. It's therefore a commons or a shared heritage or the province of humankind, the province of mankind. So they're quite vague terms in a legal sense, but there's a very strong sense that therefore everybody should benefit. And that goes along with the other language in these treaties, that there should be freedom of access, benefit with no discrimination. And it possibly can lead to the tragedy of the commons. So we've learned also throughout history that where there is a commons, where everyone is supposed to have access, it can also get used up very quickly because there's no one really concerned for the longevity of it. And that's where our responsibility around sustainability and intergenerational responsibility does come in. And it also goes to the attempts in or I should say the principles outlined in the Moon Agreement with the intention that this should become an international regime, that distribution of those benefits should be part of that. Rent tax has been proposed here. How do we deal with the ethical and geopolitical issues of equity and global distribution of natural resource profits? And someone referred to what I think is an excellent series that everybody should watch if you have not already, the National Geographic series simply called Mars, which is a mixture of interviews and a documentary with people who've been thinking about these issues from a lot of different perspectives, and then a fictional storyline that plays out those issues in the 2040s with the first human settlement on Mars. And one of the scenarios was that a commercial company landed next to where a scientific community had already been established, and there was a great deal of contention between them because the commercial company was simply interested in getting a return on investment and getting a profit, and therefore perhaps using up resources or bringing into danger the scientific experiments. And so this idea of ethical distribution comes into it again. Clearly, if we're going to be moving into these kinds of activities and combining that with human habitation in a space station or human habitation on the moon and eventually on another planet, we need to be thinking about that longevity, about distribution over generations, about human habitation being able to depend on those resources. So all of those issues have been raised, even if there is some pushback at the moment. There's certainly nothing in what we've seen from what's going to be in the Artemis Accords to cover that. Again, I think I want to turn back to the fact that Andrew and I highlighted this is actually an opportunity for Australia to make sure that those kind of things do get put in place for the benefit both of the commercial industry that wants to take part in these activities and for future generations. So I'm going to go in reverse order. I'm going to say Andrew, then Annie, then Nikki, then Don. Andrew, you're on mute.
Yeah, just a couple of points. maybe relating to your tragedy of the commons, actually. So coming back to safety zones and what they actually mean. I think there is some sort of gentleperson's agreement about the Apollo sites, for instance. So the idea is that you don't land nearby to the Apollo sites, because if you throw up dust when you're landing, then you'll damage that area. And that's something that they're heritage sites, right? They're sort of famous pieces of human achievement, whatever, which the Americans would agree with. They would agree that we want to protect those things. Now, having said that, Alice Gorman from Flinders University has this idea of, well, the permanently shadowed craters on the moon are very unique places. They're some of the coldest places in the solar system. They haven't seen the sun for 1 billion years. We should protect some of them, right? So we should. An idea which I've had the chief scientist of a NASA mission just laugh out loud at. So this idea that the Americans own space and they want to protect their bit, but nothing else, is a thing. But just thinking about what safety zones are. So if you're going to say, all right, I'm going to extract water in this area, I don't want anyone else to land within that area because any dust that they throw up will damage what we're doing. Then if you're operating in that area, how do you avoid the same damage being done by your own spacecraft? What does this mean? If you can land there, why can't someone else land there? And so what does a safety zone mean? And there probably it needs to be carefully drafted, because if you're landing and launching spacecraft from the moon surface, then there's an incentive for you to protect your own area by putting up blast shields around your landing site. And that will minimize the amount of damage you do, because there was some evidence that in the Apollo missions that the dust that was raised went all the way around the moon for a little while. So whatever damage is, it can be quite extensive. By that I mean in how far it goes. So if you want to protect yourself, you can build one of these blast shields, and then so you can protect your area. But if the protection zone is how far your dust goes from a launch and launch and landing, then there might be a disincentive for you to build the blast shield, because then you can claim a larger area. So we need to be very careful about how we go about these things, is all I'm saying. And I'll probably stop there and go on to the next person.
Thank you, Andrew. I'm wary that we've actually reached an hour and a half. Don, you have to leave us, so I'm going to give you an opportunity to give your final comments now.
Thanks, Cassandra. Very quick points. First, there needs to be a recognition that the global international community is dealing with treaty fatigue, so the negotiation of new multilateral treaties is exceptionally difficult. Secondly, the leadership historically exercised by the United States in terms of multilateralism and multilateral treaty negotiation is completely absent at the moment. Thirdly, we've spoken quite a lot today about the opportunities for Australia, and I think that there are opportunities, and Australia has from time to time exercised some real leadership in certain particular fields in terms of pushing forward new international instruments and frameworks, but the diplomatic obligations, the diplomatic cost, and the significance of being able to move that forward really can't be underestimated. It's a very big initiative for a country like Australia to do on its own. I think it could only do so joining with some other international partners. Thank you, everyone. I have to go, unfortunately.
Thank you so much for your time and your contribution, Don. So just very briefly, excuse me, Nikki and then Annie.
So the dramatic decrease in the cost of space operations has made all of this discussion possible. So the fact that the cost of doing things in space has actually gone down has enabled commercial operators to actually do a lot more. It's enabled new space agencies to pop up, including our own. And I think actually that is great, because it's a wonderful time to be alive in regards to all the amazing things that we're going to be doing in space. And I think the Artemis Accords actually gives me great hope that we're actually starting the discussion discussion around how we are actually going to handle this going forward. I just think the most important thing is that we get it right.
Thank you, Nikki. Annie.
Thank you. Look, I think this has been a really great conversation. I think Australia is often wary of taking the lead internationally, and I acknowledge the truth of what Don said, that it's difficult, but I would say that I think we owe it to my generation and to future generations to give it a go. The world's in flux. There's never been a better time to shake things up a little bit and see what happens. So I would say let's continue this conversation and encourage our leaders to decide and communicate a really clear stance on what we want the next couple of decades in space to look like from Australia's perspective, and to focus on equity, shared responsibility, and peaceful cooperation.
Thank you, Annie. So unfortunately, Andrew, we're not able to provide that clarity and certainty at this point in time through a discussion like this, but I think we've covered a lot of ground and a lot of issues and highlighted what really does need to be looked at and what the opportunity is for Australia. So this whole webinar has been recorded. I understand that we still need to ensure we have agreement from all parties who've taken part, but if there's a release, then the webinar will be posted. Andrew, where would people be able to find that? Oh, you're on mute again, sorry.
Yeah, we can email a link out to people to inform everybody afterwards, yeah.
Fantastic. So I really want to thank you all for your time and your contribution and your thoughts on some really difficult issues. And thank you again to ACSER for hosting the webinar. Thank you, everyone.
Thank you.